Coast Berbice. Welcome to another program of Issues in the News. To our viewers who are joining us on television from across the Berbice River, along the east bank of the Berbice River, New Amsterdam, Kanji, welcome to another program of Issues in the News. And to our viewers again along the Quarantine Coast, all the way to Siparuta and Oriala, welcome to another program of Issues in the News. To those of you who are joining us on Freedom Radio from Robb Street, Georgetown, welcome to another program of Issues in the News. And last but not least, to the thousands of you who are joining us on Facebook Live across the length and breadth of Guyana, the Caribbean, North America, Europe, Asia, as far as Australia, and the Middle East. Welcome to another program of Issues in the News. Please share the live. Press the share button on your phone, on your computer, on your iPad, or wherever or whatever you're looking at the program on. Share the program so that all your friends and all your followers can join us in tonight's discussion. So share the program and use the comment section, of course, to let me hear your views. I want to be as engaging as I possibly can. Arjun Jawahir, Hukum Chand, Ivorine Ramcharan, Rajendra Singh, Fred Samwaru, Shifa Hussain, Shirley Surajbali, Betty Chris, and so many of you. The screen is moving so quickly, I can barely recognize your names. So you are on. Let us start. Please share with me your questions. Share with me your comments. Use the comment section for that purpose so that we can have an engaging program. So you would have seen last week in the news, it was published that Chartered Accountant Christopher Ram, as a litigant, has filed a certain legal proceedings in the High Court of Guyana, in which Mr. Ram is seeking to have the court declare that an individual person can contest the national and regional elections without being part of a list of candidates. And he is asking the court essentially to direct the Guyana Elections Commission to permit a person to contest the elections without being part of a list of candidates. I am not clear what Mr. Ram's intention is. Neither am I aware on whose behalf he purports to act. But in my respectful view, having examined the relevant provisions of the Constitution and having examined the relevant statutory provisions touching and concerning national and regional elections, it is my respectful view that the action is without merit, is spurious, and vexatious. The Constitution of our country, which is our supreme law, establishes our electoral system and outline in sufficient details how our elections are to be contested at the national and regional level. And the relevant provisions of the Constitution provide very succinctly and with great clarity that those elections must be contested by a list of candidates or by candidates who form part of a list of candidates. So persons are not precluded from contesting the elections, but the Constitution mandates those persons, whomsoever they are, to form themselves into a list of candidates. And the court cannot permit something to occur in the electoral process that is not permitted by the Constitution. Or even more emphatically, that is precluded by the Constitution. And an individual contesting the elections without being part of a list of candidates is precluded from contesting the elections. Recall the Constitution being paramount and being supreme means that the court is subject to the Constitution. The president is subject to the Constitution. So it is the Constitution that will direct how the court acts and not the other way around. And if the Constitution doesn't permit something, a court cannot direct it to take place. It is as simple as that. So, Mr. Ram is essentially inviting what Ram should be advocating for is constitutional reform. What he's seeking to achieve can be achieved through litigation, but can only be achieved through constitutional reform. And that is where his action should have been directed. Perhaps to the Constitutional Reform Commission. His action meaning not the litigation, but at the appropriate time he should make submissions to the Constitutional Reform Commission and advocate that cause. Not go to the court and invite the court to do that which the court doesn't have the power to do. So I thought that I would express a view on that matter because many persons have asked me to do so. We will have a sitting of the National Assembly on Monday, the 28th of April. That's Monday coming. And a number of important pieces of legislation will be debated and hopefully passed at that session. Also, a number of important bills will be laid at that sitting of the National Assembly, including the Oil Pollution Prevention, Preparedness, Response, and Responsibility Bill of 2025, popularly referred to in the press as the Oil Spill Bill. The proper name for it is the Oil Pollution Prevention Preparedness Response and Responsibility Bill of 2025. Is a landmark bill establishing a robust, modern, and comprehensive legal framework to govern the prevention of, preparedness for, response to, and liability resulting from oil spill incidents from installations and facilities engaged in petroleum operations under the Petroleum Activities Act across the national territory, including Guyana's territorial sea and exclusive economic zone. It ensures that every person and or entity involved in any petroleum activities, including drilling, exploring, producing, storing, handling, transportation of petroleum products, oil, gas, etc., shall be held to the highest standards of operational safety and environmental responsibility. The bill also enshrines liability for those who may be responsible for any form of oil spilling or any negligent oil operations that lead to damages of any kind. Significantly, it doesn't limit liabilities, and it provides very clearly for the responsible party to be held liable for all damages occasioned by the act or omission of that party. It provides a dispute resolution mechanism within the bill, but it also preserves the right of any aggrieved person to approach the High Court to seek remedies, including compensation, in relation to any petroleum activity that may have caused damage to one's property, person, or the environment. This bill complies, well, not complies, but this bill brings to Guyana the international standards and the international duty of care which the law requires at the international level for operators in this sector to be measured by. It brings into Guyana the international standards for the industry. So it's a crucial bill, and it's a landmark legislation that we are introducing. And you will recall that it took quite a while in preparation, and that's because of its complex nature and because of the care that had to be exercised when treating with this bill. So once the bill is laid in the National Assembly, of course, it would be circulated widely. I want to spend some time in dealing with, before I get there, I saw in the news some statements made by the leader of the Alliance for Change in relation to the incident, the unfortunate incident at Linden last week, where two persons unfortunately met their demise, allegedly at the hands of the Guyana police force. It is public knowledge that the president intervened, met with the family, and assured the family and assured the public that an independent, professional investigation will be conducted and justice will be pursued swiftly against those who may be implicated based upon the investigations. Guyana is a country governed by the rule of law. And the rule of law dictates that when incidents of these types occur, irrespective of how gruesome they may appear, irrespective of how guilty some person may appear, the rule of law dictates the requirement for due process. And due process involves investigating and extending an opportunity to those who are implicated to answer to whatever allegations may be put to them in the course of that investigation. These are all elements of due process. They are all elements of fairness. They are all elements of what the rule of law requires. The alternative to that is to conclude without any investigation that Tom Jones or Mary Jane is guilty and then move to execution or move to punishment. That is what is called anarchy. In a civilized society, an investigation must be done, and that investigation requires due process to be extended to both the victims as well as the villains. And eyewitnesses are also required to be interviewed so that important and necessary bits and pieces of evidence is accumulated. There is no other process in the civilized world. And that is what the government committed to. Recognizing that it is the police, the president said that the regional security systems, RSS, will be engaged, and the Office of Professional Responsibility of the Guyana Police Force will also be engaged. And together, they will conduct the probe. That was done. And today, I am told, it's in the newspapers, it's in the news, that the file has been transmitted to the Director of Public Prosecutions for advice. Again, that's an independent constitutional office established by our Constitution to perform that particular function. You will note that the file didn't come to the Attorney General office. Neither did it go to the office of the Commissioner of Police. It went to the office of the Director of Public Prosecutions. And that is how it is done. In a constitutional structure like ours, And there are about 55 countries in the world, part of the Commonwealth, that has a system similar to ours. And that is where the file is now. Nigel Hughes is a lawyer. He knows all of this. Yet, he is quoted in the press as making the most reckless, irresponsible, and inflammatory statements. And these are not isolated statements. These are statements that Nigel Hughes has consistently shown a proclivity for publishing. And perhaps I will have to do an entire program to show you how many times Nigel Hughes has made statements of this type. He says if you want to pay tribute to these two sons, do not accept the police investigation. Do not accept the investigation of the RSS. You need the best forensic experts from the world to come here, and not the Guyana Police Force, and not the RSS. So, Nigel Hughes is telling the country to disregard the law enforcement agencies of Guyana, disregard the regional security system. This is a regional law enforcement agency, a Caribbean mechanism. Disregard them too. So, whom should we get to investigate these things? And on what basis he is jumping to these conclusions? He will tell you about the Henry boys. The truth of the matter is, the 3 or 4 persons have already been charged with the Henry boys. 2 or 3 of them have confessed to the crime. But Nigel Hughes and persons of his ilk, that doesn't satisfy them. They want more. I don't know what they want. Maybe they want some PPP minister or PPP leader to be implicated in the killing, and only then they will be satisfied. What evidence does Mr. Hughes have to suggest that the investigation is somehow compromised? And as I said, I will deal elaborately with his record in relation to police investigations. You would recall the same forensic people. He's speaking here of a forensic expert. You will recall in 2012 when they had a shooting in Linden and persons died and others were injured. And there was a commission of inquiry. Nigel Hughes brought a forensic expert. First of all, he went to the families and he made all types of promises to them that he will prove this and he will prove that and he will establish X and he will establish Y. He brought a forensic expert somewhere from South America. I believe it may have been Colombia or Peru or Argentina, I'm not sure. But one of those South American countries. Check back the newspapers. And that forensic expert did not prove anything close to what Nigel Hughes said they will establish. In fact, the forensic expert confirmed what the findings of the Guyana Police Force was at the time. And Hughes was very embarrassed. He walked out of the Commission of Inquiry. Check your newspaper's article, Google it. 2012 Linden Commission of Inquiry. That is the same thing that he's doing here. Same thing that he's doing here. And he's demanding monies from the government, taxpayers' monies, mind you. The government was fined hundreds of millions of dollars. Now, the government is not ruling out any form of compensation, but things have to be done in a proper way, in an orderly way. You must have an investigation. There must be some findings, and then certain eventualities will flow. This gentleman has absolutely, he is out of his depth when it comes to responsibility and duty of care to offices and to public funds. So the government was dole out taxpayers' money without even an investigation being done and without any finding whatsoever. Things are not done like that. A government has to act responsibly and has to act upon empirical evidence and upon recommendations that are studied and produced from an investigation. This is not a knee-jerk process, and that is why every time this guy speaks and everything he does demonstrate beyond a shadow of doubt that he cannot be anywhere close to a government. He cannot be anywhere close to a government. He doesn't have the sense of maturity, and he doesn't have the presence of mind. But as I said, I have some other issues that I want to deal with tonight. So I will dedicate an entire program where I will elaborately address issues of this type implicating Mr. Hughes in very, very similar conduct in a number of different instances. And I'll show you the propensities that he is guilty of. So, great weather, I see, is being made of a State Department report which was handed down some time ago, but I don't know, recently discovered, or today discovered, because of an article, I suppose, in the Starbrook News newspaper. And I responded to the report. But of course, I see the glee, because the report from some perspective is critical of the government. You have reporters who are obviously critics of the government taking great glee and an appreciable sense of happiness in writing about the report and publishing the report. So I want to respond on this program to some of what is being published in relation to this report and the stories surrounding the report. So the report dealt with Guyana's anti-money laundering and countering the financing of terrorism framework and capabilities. And went on at depth to comment on this framework. This AML-CFT falls under my portfolio responsibility, as Attorney General and Minister of Legal Affairs. I am also the chairman of a national task force on AML CFT. So it is my responsibility to respond to this report, in particular as it relates to Guyana's AML CFT framework and capabilities. Now, I recall some months ago that a questionnaire came from the publishers of this report asking some questions, and a lot of information was supplied based upon the questionnaires. Unfortunately, they were not included. A lot of the information was not included in the report. But what is important is that countries' AML CFT framework, capabilities, and credentials are governed by and supervised by and adjudged by, governed by, supervised and adjudged by an organization in this hemisphere established for that purpose, and that is the Caribbean Financial Action Task Force. That is the body that is appointed by the Financial Action Task Force, the global body, to regulate AML CFT framework and standards in this hemisphere. It is the Caribbean Financial Action Task Force that examines the jurisdictions of this hemisphere to ensure that they implement the international recommendations and standards, and that their financial systems, their law enforcement capabilities, their laws, their administrative protocols, and their national and international collaborations meet international standards. That is the CFATF's function. And Guyana is very much part of that rigorous schedule that CFATF presides over. And Guyanese, more than perhaps most other countries in the Caribbean, most other citizens in the Caribbean, are not unaware of the situation in respect of CFATF, because we have had bad experiences when the opposition, using their one-seat majority, voted down critical pieces of legislation when we were in a minority government. So the Guyanese population are very much aware of CFATF and the role they play in the region. And that is why we say that CFATF is the authorized agency to express opinions and pass judgment on matters of an AML CFT nature, and with the greatest of respect to the State Department. That is not their functional responsibility. In fact, I don't know what criteria they are using to make the conclusions that they have made. It is public knowledge that from 2022 to about 2024, Guyana underwent an 18-month mutual evaluation, examination, and assessment, where every aspect of Guyana's financial structure, every aspect of its AML-CFT regime, its legislation, its public and private sector apparatus, its banking sector, and all its law enforcement agencies were the subject of scrupulous scrutiny in this examination exercise, both onshore and offshore, meaning that experts from the Caribbean Action Task Force came here and spent 2 weeks at a time interviewing persons right across the state spectrum, including the private sector, on various matters after studying all the protocols and all the legislative framework. They had one-on-one engagements with law enforcement agencies, the Guyana Revenue Authority, the Guyana Gold Board, Geology and Mines Commission, the Central Bank, the commercial banks, all of that. They looked at our legislation at length, our legislative framework, and in the end, at the end of that process, we had to defend an evaluation report at a forum in Trinidad in front of the whole of the Caribbean and Central America. The United States of America itself is a member now of CFATF, and they were present, and they participated in the exercise, where Guyana AML-CFT framework was laid bare, and the report, we had to defend the report. And at the end of that process, Guyana came out with excellent evaluations. In fact, Guyana did better than almost every independent Caribbean state in the fourth-round mutual evaluation process. And our ratings were sent to the Financial Action Task Force, where it received that agency's approbation. And that is the international standard bearer on AML-CFT. Once you meet that approbation, once you pass that assessment, and you do so with flying colors, which we did, that is conclusive. There is no other agency now that can come and second guess that. And that's my problem with this report. So I promised the press that I'll release something in writing which I have prepared, because I listed all the things that we have done, the crucial things that they mentioned in the report. And we have done that, and we were assessed on these matters. And as I said, we received high commendations. Of course, recommendations were made for us to make further improvements, and we are in the process of doing that. And it's an ongoing process. We have to report in October later this year on the improvements and the advancements that we have made since our last assessment. And that's an ongoing process. So we made tremendous progress in terms of beneficial ownership. We amended our legislation, and we put in place a beneficial ownership register at the commercial registry so that every person who goes there to register a company must say who the actual owners of the company are. That's what beneficial ownership means. That you must not hide behind a cloak anymore. The corporate veil must not be used to disguise and conceal the real owner. That is what beneficial ownership is. And we have put that in our law now. Every company got to come forward and say who are the real shareholders of those companies. And we have the most modern mechanism in place to ensure that takes place. And when they fail to do so, we exercise a penalty in our law, that is to strike the company off the register, which is the most draconian of all the penalties. And we have that in our law. And that is why only last month, an Article 4 mission from the International Monetary Fund examined Guyana's AML-CFT credentials and framework. And they made a finding which they published in their report. And I will send out their findings. I don't want to read it to bore you. But in there, they give a long 2 paragraphs on Guyana's AML-CFT framework. And they made reference correctly to CFATF's assessment. And they saluted Guyana, this body, this Article 4 mission from the IMF. They saluted Guyana on the accomplishments that we have made in our AML-CFT framework and credentials. In terms of money laundering and corruption and organized crime, we are saying that once we have evidence of corruption, in particular in relation to public officials, actions are being taken and will be taken. And I cited the case of Calvin Brutus. And we cited the case of Calvin Brutus to the Caribbean Financial Action Task Force. And the assessors did a case study of Calvin Brutus' case. They examined the allegations and they examined critically the investigation that was done, the advice tendered by the Director of Public Prosecutions, and the charges instituted. The entire symposium studied that case. They studied 4 cases from the Caribbean, including Brutus' case, which we submitted. And we said, judge us. This is an investigation of a high-ranking state official, to wit, an assistant commissioner of police. And this is the type of work that we have done. We submitted ourselves for examination and scrutiny. And in the end, we got the best case award. I see some fun is being made of that somewhere in the social media, as though it didn't happen. Matthew Langevin, the director of the Financial Intelligence Unit of Guyana, he accepted the award on behalf of Guyana. It was published in the newspapers. Go and check it. So, how can you fault Guyana when we, by the authorized agency, the globally appointed agency, we have won an award and we got a clean bill of health on this very matter? Then they made reference to the OFAC sanctioned officials. Again, it is a fact of public notoriety that as soon as the US announced those OFAC sanctions, the government of Guyana responded and said in a public statement and in a statement to the U.S. law enforcement authorities that the state of Guyana is prepared immediately to engage you in rendering mutual legal assistance on this matter. And it is also a matter of public notoriety that an engagement has begun and is ongoing. Large volumes of information have already been sent by agencies of state in Guyana to law enforcement agencies in the United States in relation to the sanctioned persons and companies. In fact, today, another set of information and evidence requested was sent up to the U.S. The Guyana Revenue Authority, the Financial Intelligence Unit, the Special Organized Crime Unit, and many other agencies are working assiduously with the U.S. law enforcement agencies in relation to the sanctioned matters, sanctioned persons. But here is the duplicity. Let me pause to dilate a little on the duplicity. At one time, they were saying that we will never charge, that Brutus will never be charged. Same persons who are maligning us now with this report, they were saying that Brutus will never be charged, that Brutus will be protected by the government. They were saying that the police can't investigate Brutus. The opposition forces were taking that position. And then Brutus was investigated by the police and charged. And now they seem to be supporting Brutus. These same opposition persons and sections of the media. And they seem to be supportive of Brutus and Brutus's wife. Then look at the sanctioned persons. When the sanctions were first announced, they said that we are in bed with the sanctioned people, that we will protect the sanctioned people. Now, they are on the side of the sanctioned people. The same press, the same opposition, they are now on the side of the sanctioned people and sanctioned companies. The public record will show, and the U.S. knows, and the sanctioned persons know, that from the moment the sanction was announced, the government of Guyana began a process of disengagement to protect the processes and the systems of Guyana from any negative and deleterious consequences which may flow from the sanctions. That is the government's record on this matter. Then we are told about how many charges we have filed in the system. And there was negative commentary on our rate of convictions. Well, that also came up when we were being assessed at the Caribbean Financial Action Task Force. And I made it clear then, and I'm going to make it clear now, that we have a democracy in Guyana. We are governed by the rule of law, and we have separation of powers in our country. The law enforcement agencies shall investigate, and the DPP recommends charges or does not recommend charges. And when charges are instituted, they go before an independent judiciary. The law enforcement agencies can present the evidence, and they do present the evidence, but there is no guarantee how the evidence is treated by the judiciary and how the cases are decided by the judiciary. That's a matter for the judiciary. Many of you know my views on certain issues in relation to the judiciary. So I don't want to start there. But when the cases go before the judiciary, you can't blame government. You can't even blame the police force for the rate of conviction or acquittal at the judiciary, at the level of the judiciary. Currently, there are 298 money laundering charges in the system. 298 money laundering charges in the system. But I can't sit here, or no government official can sit here and tell you whether or not we are going to get 298 convictions, or whether we're going to get any conviction at all. At the level of the government, you could give policy directions to the police force to ensure that the evidence is presented. That's all you can do as a government. And what is important is that we have strong, harmonious, and strident working relationship with every major law enforcement agency in this hemisphere, including those in the United States of America. We will pass a bill come Monday that will incorporate the RSS as part of the law enforcement apparatus of Guyana. The RSS will become part of the law enforcement apparatus in Guyana. We are passing that law Monday coming. We are now part of Egmont, where we have joined nearly 150 countries worldwide to share platforms and cooperations, exchanges of evidence and assistance with about 140 or 150 countries across the globe. So Guyana's credential on the AML CFT front stands as good, rather better than most countries in the Caribbean. And we are committed to continue to work to ensure that our system remains insulated from these threats. We could never reach perfection. That will always be an aspiration. It will always be a goal. But we may never achieve it. But I can tell you that we are doing as good as any other country in the Caribbean on these matters. And the archival record of the appropriate agencies on these matters will support the position that I am adumbrating here tonight. And that is what is important. With the greatest of respect to the publishers of the U.S. State Department report. I will put out some of this information tonight so that the press can use it in their stories for tomorrow on this matter. We continue to work fervently in Guyana with the CFATF, because in 2026 we will undergo another round of evaluation. So we now have to implement recommendations coming out of our mutual assessment report, because as I said, while we scored high, we were not perfect. So there are recommendations in there that we have to implement There were deficiencies that were identified, and we are addressing them. Once we address those, and we concluded that aspect of it, we now have to prepare for another round of mutual evaluation. It is a cyclical process that keeps us under scrutiny and under an obligation to comply on a regular basis with all the international and global standards and protocols on these matters. So, we have now come to program time. I'm sorry I didn't realize that I've spoken so much on these matters. I'm sorry if I may have bored you. I know you like more hot and steamy topics, but tonight I had to spend some time in addressing these issues because I felt that these reports, when they are published, people take from them that which suits their particular agenda, and they do not highlight a lot of good things that are in the report. A lot of good things are in the report too, but you won't get that in the press. We may have to put out that separately, but I believe in my analysis tonight, I may have highlighted some of them. So I want to thank you very much for spending the past hour with me. I think that we have covered a great number of important issues. Most importantly, I hope that I have brought some clarity to the US report that is making the news with so much drama. I hope that my input will bring some degree of balance to the information being disseminated. Thank you very much, and please join us next week as we continue our discourse on issues in the news. Stay happy, stay healthy, and may God bless you. I'll see you next week. Thank you.